Welcome, everyone, to episode 19 of the Argument Clinic. Really excited to be here with you this week. My name is Martin Sigalo, and I'm joined by my lovely co host, Lawrence Zhao. How are you doing, Lawrence?
I'm doing pretty well. I apologize if my voice sounds awful. I've been sick for a bit, so I'll do my best to make it through this podcast.
Yes. If you don't quit because of my stupid jokes or your sickness, then at the end, Lawrence, I will award you with $0. Um, how do you feel about that? How do you like being gifted $0?
It's not great, but better than literally nothing, I guess.
It really, I think it is literally nothing. Um, so where were we for the last few weeks? I think the last episode we did was the weighing episode 2 weeks ago. That episode has done really well.
That was like
In
a
the
month ago.
in the meantime, was it really that long ago?
Pretty sure, yeah.
Oh, because we took the Thanksgiving stuff off. But in any case, it's been quite some time. We had our weighing episode that did really well. We are back at it again with another topic analysis episode. In the meantime, we went to Glenbrooks. We saw each other. I don't know remember if we talked about that on the last episode. I don't think so. Um,
Well,
and
how could we have Glenn Brooks had not yet occurred?
all we had a great time chatting about the Glenbrooks. It was or chatting at the Glenbrooks. It was fun. It was a good tournament for my students, although it cut out a significant part of the break. And those of you who went, especially those of you who went to the round robin, will know exactly what I mean. Okay, so what are we? The Argument Clinic podcast is a podcast about debate fundamentals, specifically Lincoln Douglas debate fundamentals. The idea is that our podcast should be useful, whatever level of debate that you're at, whether you are a grizzly veteran of the tournament scene, which is like a grizzled veteran, except you're a bear. You are a star-studded debate coach. You have all the diamonds you could offer, but you still want to learn things about the topic or hear alternate perspectives, or whether you're just a brand spanking new novice looking to mosey your way on down to some tournaments and collect some wins, collect some losses, but you want to improve yourself at the game. This is the podcast for you. We are trying to help everyone improve at their game, regardless of their skill level, by teaching broadly applicable topics that can apply to everyone. So for this resolution, we're going to do a scholarship episode on the very new resolution about plea bargaining being abolished in the United States criminal justice system. Lawrence, how do you feel about how doing a topic analysis so early in the topic?
I'm going to pretend like I've read things about the topic. I'm just kidding. I've actually read things about the topic. But yeah,
Oh, boys. We did it. Okay, so a couple of things before we get into the episode. Remember to check out our past episodes of the podcast on SoundCloud. Our SoundCloud page at the Argument Clinic has a lot of really good content stretching back even to our first episode on judge adaptation. The podcast is almost a year old, and there will be almost 20 episodes up even after you finish this one. There are a full 18 episodes with things like drills to improve at persuasion, judge adaptation, evidence comparison, weighing, tons of other things, as well as topic analysis episodes for past topics, although I don't know why you would want to listen to that. Two, we want to shout out our sponsor, Victory Briefs. Victory Briefs Institute is a great summer camp that allows you to go and hone the best of your skills with some of the best instructors in the country. And I've taught there a few times, and I can say it is the real deal. It's really good. If you want to hear a more goofy take on VBI, we actually recorded a live episode at VBI, me and Lawrence, and that's because working in a very good capacity there at VBI. So, Lawrence, how do you feel about the VBIs?
well, I think since the last time we had this podcast, we've actually announced dates and locations for VBI, which you can just check out at the blog, which is vbriefly.com, or the camp website, which is vbidebate.com.
Okay, good stuff. And the last thing is that we have an excellent guest who we will introduce as soon as we get into the episode. But again, scholarship episode, new topic. We want to be the first ones to talk about it in an intelligent way. So before you see any other resources, this is also good. Lawrence, you're saying that you want to say something?
Oh, yeah. And one thing we'd like to say is just recommend this podcast to whoever you think needs it. We'd like if this podcast could reach a wider audience. And so if you just have friends, that may not even be like at the same school as you or whatever, just, anyone you think could benefit from this podcast, we'd really appreciate it if you could spread the word around.
The idea is that our podcast is like a poison that gradually seeps through the underground of the debate community, infecting the roots and making sure that everyone knows what weighing in arguments are and what the topic is. So try and infect as many of your friends as possible, spread the poison to as many people as you can, and that would make us immensely happy. We, of course, get absolutely $0 from doing this podcast. Absolutely nothing. So the only thing that we're doing, the only thing that we want is for our podcast to be listened to by all the other people and for as many people to get as many of the benefits as possible. So please just make sure that if you think someone could benefit from it, that you send it to them. And when we come back from the break, we'll introduce our guest and then start talking about the topic. So before we jump into the topic, we would like to introduce our guest, Jessica Zhang. How are you, Jessica?
I'm good. Thanks for having me. I'm honored.
Thank you so much for coming on. Don't be honored. This isn't that honorable of a podcast. Lawrence, are you honorable?
No.
Yeah.
Didn't you
if
call you that on your paradigm at one point?
the honorable Lawrence Zhao. It's true. Lawrence was edited.
It's an old version, although there's a
old version. Ah. No
yeah,
defense.
I was entered in tab room as that, but that's no longer it's no longer my judge philosophy page. I had to make it a real one.
It was a judge philosophy page?
For a while.
Wow. Yeah, well, Jessica, you're honorable, and Lawrence is honorable by default. So I guess it's a 2-1 in favor of honor. I'm definitely dishonorable. Okay, so Jessica, you debated in Texas, is that right?
Yes.
Where exactly in Texas?
The Woodlands College Park. It's a small school, and it's growing for sure.
What would you say is your best debate achievement you personally? You can have one that's like a serious one, and then one that's kind of just like a funny thing that happened.
I don't know. I guess my best achievement is being undefeated against Harvard Westlake.
Well, really? Aw, that's awesome. And no offense to Harvard Westlake, love Harvard Westlake, but
yeah,
that is quite impressive.
It's an achievement to beat any of them.
It's true, and because they're so good. And what would you say is like a funny achievement if you have one?
My
funny achievement is that I had a debate with
how to go vegan for a day, and Michael
that's pretty good.
Meat eaters.
Did he go back?
Yeah, very quickly.
Well,
but nonetheless, still an achievement.
Okay, well, thank you so much for agreeing to come on our podcast. Let's talk about the resolution. And for those of you that haven't listened to a podcast episode of Topic Analysis by us before, the first thing that we do is we read the resolution a few times to make sure that you all have a sense of exactly what it is. And then we're going to go through it word by word and kind of pick apart the context of the resolution. This resolution, even though it doesn't have that many complicated words, has a lot of important context surrounding it that we feel it's important to kind of help you understand about the resolution. Okay, so the first thing I'm going to do is I'm going to read the resolution a couple times slowly so that you all that don't already know it can kind of process it, and then we're going to pick it apart important word by important word. Okay. The resolution is plea bargaining ought to be abolished in the United States criminal justice system. Lawrence, do you want to read it?
Okay, I'll try my best.
Bless
Plea
you.
bargaining ought to be abolished in the United States criminal justice system.
All right, 2 for 3. Jessica, you want to turn?
All right. Plea bargaining ought to be abolished in the United States criminal justice system.
There you go. If there's even one of us whose voice that you do not find annoying, then you'll have heard the resolution by now. So that's good. Let's talk about some of the easy words, kind of get them out of the way. So ought. We've had the word ought in LD topics for a while. It usually means something to do with morality or something to do with should. It's a recommendation. It would be good if plea bargaining were abolished in the United States criminal justice system. Importantly, Lawrence, the resolution does not talk about plea bargaining's necessarily legal status. So the resolution isn't asking whether plea bargaining is legal or not. right? What sort of question is it asking instead?
A values question or a morals question? Woo.
Woo, indeed. And by that you mean it's not whether or not plea bargaining exists, or it's not whether plea bargaining is lawful, but it's whether plea bargaining should exist or should be lawful.
Yeah, in a
Okay.
value sense.
Okay, I won't waste any more of our time by talking about that. Let's briefly talk about the United States. I just want to briefly say that this is the United States legal system, and if plea bargaining exists elsewhere, those pieces of evidence are probably not relevant. Okay, so the next phrase in the resolution, the next most important phrase, is criminal justice system. And I kind of wanted to talk about the criminal justice system and the general process surrounding that before we get into plea bargaining specifically. So, um, so I have taken a number. So I've had a lot of legal topics. I actually debated this topic before, or at least a version of it, in one of my younger years. And I took a bunch of political science classes on law, and some stuff involving plea bargaining when I was in college. So I feel like I have a pretty good basic content knowledge, and I know Lawrence and Jessica do as well, based on a lot of their readings. So, criminal justice system. There are a couple of quick distinctions that I want our audience to be aware of that are kind of going to be important, or at least important general knowledge to have when going into the resolution. Okay, number one is the distinction between civil versus criminal courts. Lawrence, would you mind explaining what the difference is here, between civil and criminal courts? They're different court systems entirely. What's the difference between them, and how does that factor into the resolution?
Well, so crimes are offenses against the state and are generally things that like harm society as a whole, and so are prosecuted by the state. Whereas civil cases are just disputes between individuals, typically regarding like the things and that they owe one another, and those are adjudicated through civil lawsuits. So they're entirely different.
Okay, so Jessica, would you mind saying, like, what are the sorts of cases? What kinds of cases are civil cases, and what kinds of cases of criminal cases? Like, can you just like what are some examples of those
Sure.
things?
So civil cases would be, for instance, like breaches in contracts between two parties. Marriage and like a divorce cases are civil cases, versus like criminal cases are more like you've broken like a law, such as like stealing or murder, or like tax evasion is like the criminal case.
Uh-huh. So by crimes against quote unquote the state, it doesn't mean that you necessarily have to like harm the government quote unquote directly. It just means that there are some crimes that are kind of deemed of a serious and interpersonal nature enough that that they are deemed criminal. Um, I have another question for you, Jessica. So there is something in the United States legal system called double jeopardy, and double jeopardy says that you cannot be tried twice for the same offense. Which is to say, if you are acquitted of an offense by a formal court of law, the state can't try you again, and that's obviously to prevent the government, if it wanted to, from just trying someone until they ran out of money. So, if you can you be put in a criminal court and a civil court for the same offense? So normally double jeopardy would kind of exclude doing that, but is it possible to be charged in civil court and criminal court for the same kind of thing?
I would say no, because they seem to be dealing with two different types of trials or two different types of offenses. So I guess the result of each case would be different, and like the like function of each system is not the same. So even if like I don't think it's possible, but even if you were to be tried for the same crime, it wouldn't exactly be, I guess, like tried in the same method.
It wouldn't be the same crime because there are different kinds of things in criminal and civil courts. Um, so now I'm going to ask a slightly different question with the opposite answer, which is, can you be tried in civil and criminal court for the same event? So like let's say I like punch some dude in the face, right? can that dude bring a criminal trial against me for assault, or sorry, can the state bring a criminal trial against me for assault and battery, and then also that person sue me for like, facial damages and stuff like that?
Okay. So you said the answer already. It is indeed yes. I think the best example of this is the O.J. Simpson case, where there was both a civil and a criminal trial that occurred.
So now, as we will get into later, plea bargaining only applies to criminal cases, does not apply to civil cases. So that distinction is sort of important to understand. Now, the second distinction in the criminal justice system is the difference between the convictions or innocence or guilt phase of a trial and the sentencing phase. Most people don't realize that they're completely different parts of a trial. So, Jessica, would you mind enlightening us on exactly what the difference is and maybe how that's relevant to plea bargaining specifically?
Sure. So the convictions part of the trial occurs whenever people are trying to determine innocence or guilt, whether somebody will be charged or whether they will not be charged for doing a crime, versus the sentencing phase is whenever people are determining what the crime or what they charge for the crime is, what the punishment is for breaking the law in a criminal case. So plea bargaining occurs in the in the sentencing phase, where people are determining how severe the punishment is going to be.
Now, this is the perfect segue into the most important word in the resolution set of words, plea bargaining. So, plea bargaining, I think a lot of people think that plea bargaining is when you when a in a criminal case, prosecutor for a lesser sentence. This is what a lot of plea bargaining is most of the time. But plea bargaining, the way that we want you all to understand it, is that plea bargaining is just when a prosecutor makes a deal with a defendant at some points. You can bargain for all sorts of different things related to your sentence. You can bargain for tons of other things that we are right about to talk about. But in general, plea bargaining is just a deal. When you hear someone says like, "Hey, someone quote unquote cut a deal in the legal system or took a plea," this is what they're talking about. So what we're going to do is we're going to go through kind of the what, when, why, etc. of plea bargaining. Let's start with the when. Lawrence, at what point during a criminal trial, either before it starts or after or during, when can plea bargaining take place?
Basically, anytime.
Yeah, that's right. Will you explain?
Yeah, so I mean, like obviously, most plea bargaining occurs before the verdict is announced and sentencing happens, because you generally want to plea, and trade in deals early. But as it turns out, you can actually agree to plea bargains like after the verdict has been declared. And in certain instances, you can actually do it even after the sentence has been announced, but those are like much less likely. So it can take place at virtually any stage. Like right after you're arrested, before the charges are filed. Maybe if there's a hung jury, that might happen. So.
Yeah, tons of different places. So the when is a lot. All right, so Jessica, I kind of want to get into the how of plea bargaining with you. So how is
Yeah.
plea bargaining normally taken up?
Okay, so there's three types of plea bargaining. First is charge bargaining. So this is whenever the prosecutor will try to come to a deal on a lower charge. So for instance, instead of being charged for murder, somebody could be charged for manslaughter. There's count bargaining, which is lowering the amount of charges that someone is charged with. So instead of like, for instance, like 9 counts of like theft or something, somebody would be charged for like 5 or 6. And there's sentence bargaining, where it's the same charge and the same amount of counts, but it's all for a less severe sentence.
Yeah, so you can bargain for tons of stuff, Jessica, right? Just
Yeah,
absolutely tons of things.
part of the punishment.
Yeah, so whether or not you're guilty, what your sentence is, like all sorts of things. So There's also another sort of way that plea bargaining is kind of conducted. Lawrence, can you talk to me what like so when I watch pop culture, which is of course a thing that you can watch, um, I watched a bunch of stuff about like various mob things about cutting deals and mob people squealing on other people. Are those things plea bargaining in a lot of cases? How does plea bargaining work with respect to things like organized crime and stuff like I see in the movies? What kind of plea bargaining is that?
I mean, it can be any kind of plea bargaining because those people can bargain for, a reduction in charges. They can bargain for a reduction in, sentencing. They can. It's whatever type of plea bargaining they want. Although they usually stipulate that like they'd also like protection or whatnot. Although a lot of the movies dramatize how plea bargains work. But yeah, those are plea bargains because they'll admit to guilt for some set of crimes, and in exchange, they will offer up information which will supposedly assist the authorities in moving on higher level crime or like the sort of people who are higher up in a crime group. And in exchange, they get less prison time or less charges, etc. Well, usually the outcome is less prison time if it's because of like reduced charges, sentences, whatever.
Okay, so now that we have all of that information kind of out there, what I want to do is organize it in some ways that can make sense to you all. So let's organize this by motivation. So Jessica, the stuff that you were talking about is all examples of why someone would choose to take a plea bargain. The defendant in a criminal case, why they would want to take a plea bargain, right? Obviously,
Yeah.
they want to do it because of the effect that it has on their sentence and their jail time and stuff, right?
Hmm.
And Lawrence, one of the things that you were saying about testimony, that is, let's talk. So why, Lawrence? Why would the prosecutor do it? So like why? So this sounds so good for the defendant. Why would the prosecutor do it at all? I know you already mentioned one of the reasons, which has to do with testimony and pop culture, and we'll obviously talk about negative arguments later. But what are the main reasons that prosecutors offer plea bargains?
A few reasons. One is they like their prosecution rates to remain relatively high. So like they want their success rates to be high, right? Every person that they take to court, they'd like to say, nope, we got him, right? And in circumstances where it's get him for less or get him for
Is it like
none.
a conviction rate, right?
Yeah, conviction rate.
Correct. Or a
Whatever the
clearance
phrase is.
rate.
I don't know, but it's something up there.
The clearance rate is like I think the clearance rate is the thing that if you were doing some research you would find some stuff on. The clearance rate is how often does a case like that you prosecute like fully resolve itself.
That
And
sounds about right.
and a conviction rate is like how often they're guilty. So maybe they're shooting for a conviction rate.
I think it's a
Anyway,
conviction
sorry to
rate.
interrupt you. Go on.
Yeah, so they just want a higher conviction rate, and if it's get them for something or get them for nothing, the prosecutors are going to go for something. Number two is it
Are
reduces
prosecutors elected? They are, right?
like district attorneys and stuff.
Well, yeah.
Well, those people are.
Yeah. So are federal prosecutors not elected?
I'm pretty sure attorneys are appointed by the president. Yeah,
And
I
then-
mean, I'm
And then
pretty-
they hire their staff, right? Yeah.
yeah, and but I do think we actually elect a lot of prosecutors.
Yeah. So one really quick thing before Lawrence continues, plea bargaining applies at the federal and state level. For those of you who may not realize this, but there are two separate court systems depending on crimes. If you violate a federal statute, which is to say you do a crime that like crosses state boundaries or violates a law made by Congress, you are tried in federal court. Whereas if you violate a state law, which is the vast majority of laws in this country, then you are tried in a state court, and they are separate court systems. Both obviously involve defendants and prosecutors. The prosecutor will be what's called the district attorney if they're for the state, for the state governments and prosecutors. There are also levels of court where you can do stuff at a lower level and then appeal it to a higher level if things don't go your way. But so plea bargaining, to be clear, applies to both kinds of court system. And so one of the things that Lawrence was saying was that, like, in for some of those places that have good that are in the state level, they're elected, and if they don't have good conviction rates, then they wouldn't be reelected. Is that right, Lawrence? Did I just or did I just totally butcher what you were saying? Like,
Well,
you would
you're the one
to
who's taking
a small pig.
Well, you're the one who's taking law classes, so I'm just going to default to your expertise here.
A dangerous game. A dangerous game, Lawrence.
All right, so
Speaking of dangerous game, uh, what is a reason that a prosecutor would want to do plea bargaining versus not do plea bargaining?
okay, so number one was the conviction rates. Number two is certainty of success. I mean, these things are kind of linked together, but it's like if you're not sure that if you got the prosecution game strong, right? Like, you don't really want to sort of risk losing the case because of a jury that makes a decision that you didn't really predict. And so here you trade uncertainty for certainty, where you're certain about the outcome of a case. And that is sort of useful for the prosecution. I closely related to the first point of conviction rates. Number three is because it means they can just do more cases. I mean, it's just straight up more efficient to plea bargain with someone, because a trial takes a long period of time. But if you just throw a bunch of charges at someone and say, if you don't take the plea bargain, we're gonna stick you with these, people are gonna cave in and say yes, and that means that they can get the trial done quickly and they can do more and more trials. I feel like there's other things like the testimony thing that I mentioned earlier, but those seem to be the primary motivations for why prosecutors offer a plea bargain.
Very comprehensive. I want to add on to that last point by asking Jessica a question. So, Jessica, before we went on air, we were looking up kind of plea bargaining's frequency. Jessica, would you mind going through some of the staggering numbers about the frequency of plea bargains for us?
So at the federal level, 97% of cases are plea bargained out of, and at
Wow.
the state level, that decreases a little bit to 94%, but still
Oh,
the
no.
vast majority. But
That's so many. That's so much.
I thought I'd cut out again. Okay.
No. No, the laughing was part of the podcast.
Okay. Yeah.
Okay, go again and I'll laugh again.
Okay. At the federal level, 97% of cases are plea bargained out of.
97. Jeez.
And then at the state level, it drops a little bit, but not that much. 94% of cases are plea
94.
bargained.
Jeez.
So
that's so many.
overall, 95 to 97-ish% of cases are plea bargained out of, which
That's-
is a
that's-
large amount of.
Jessica. How did we get to all those percents, Jessica? I don't understand.
It's just it's just the better decision in terms of efficiency, defendant and the prosecutor.
So this is a question that I'll sort of ask to both of you, and it's a thing that you're maybe familiar with, or maybe not. But so how long does it take? How many crimes do you think are Lawrence? Maybe you can just look this up for this. How many crimes are committed in the United States every day? While Lawrence looks it up, Jessica, can you maybe hazard a guess? Just how many?
Wow, this seems like one of those really difficult job interview questions.
Yeah, the number doesn't really matter. Just give some random number, and then I'll give you
Right.
a bonus point if you're super close to the actual number is.
How many crimes are committed in the United States every day? Maybe So if there's about 320 million people in the United States, I believe that maybe 0.5% of them are criminals. Is that a good enough amount for people who are criminals? So that would mean that there's.
But not every criminal commits a crime every day.
That's true. Let's say out of that 0.5%, maybe half. So Mm, probably like 1% of that half of a percent commits a crime. I'll just like on a lower. I guess I'll just say about like 3,000 crimes a day.
3,000 crimes a day. Lawrence, what's the answer?
So I don't have the crime. I don't have that number, but I do have the 2015 crime clock statistics, which shows that a property crime was committed every 3.9 seconds and a violent crime every 26.3 seconds.
So okay, so
I'm just
that's
gonna
a
guess
lot.
that I'm just gonna guess that's more than 3,000, especially since if you look at the there's this like what article is this? Shoot, I lost it. Because I was looking at the crime clock. Oh, this Pew Research Center article, and it says that there are how many crimes a day? Whew. It doesn't say how many crimes a day, but it says that there's over 1 million crimes committed each year. So I'm gonna guess that the math works out to over 3,000.
Uh, okay, so 365 times 12 divided by a million. Uh, whatever. Um, okay, so here's the whole point and the reason that I'm asking you this question. Based on your understanding of the legal system, how long does it take a crime to a trial to happen and fully resolve itself?
That's a good question. The average length of a trial.
Not just a trial, but also all of the events preceding the trial, including things like arraignment, etc.
Um, so the average length of a trial is probably 4 to 5 days, but it takes at least 3 days to complete, and it can go on many a month. So could take a while.
So, so if thousands of crimes are committed like a day, and there are way less courts than there are crimes, and it takes every court about 4 days to clear a trial. If you just do that math, the numbers do not add up that you would ever be able to try anyone for new crimes, because there would just be more crimes happening that you would need to resolve, but crimes would pile up quicker than you could ever dissolve them. This has led to what's called the backlog. Have you all heard of the backlog? Have you ever debated court clog arguments
Yo.
and like had to research them and stuff? Jessica, have you? I'm interested.
Yeah, I definitely have.
Yeah, so it's like so like one of them is like, so you're familiar with the term like backlog, right? The backlog is just like the set of cases that haven't even been resolved yet because courts are still handling old cases. And so so plea bargaining is actually the major answer to that difficult question. The difficult question of how does anything ever get done in the criminal justice system if if there are more crimes per day than it is physically possible for the criminal justice system to dissolve in time? And the answer is plea bargaining. Because with plea bargaining, you can plead for guilt or and basically dissolve the entire purpose of a trial. And that allows you to get through tons of those cases. And it's the reason why that number is so enormously high. 95, 97%. Some ridiculous, unbelievable statistics that I'm sure Jessica just completely just made up and aren't like the real numbers in the criminal justice system. Just kidding. They're definitely real. And it's really scary. So, okay, now I think we have a pretty good understanding of plea bargaining and what it is. Let's quickly touch on the last part of the resolution. Jessica, what does it mean to abolish something?
Abolish means to formally put an end to or to get rid of something completely.
So if I abolish, so let's say I said I would like, so I'm like running a school and I'm like I would like to abolish lunch, and then like I'm like,
Yeah.
but we still have lunch 3 days a week, but it's been abolished.
You
Makes no
didn't
sense,
abolish
right?
lunch.
I did not abolish lunch.
Yeah.
So so Jessica, what do you think the affirmative is saying in a world where they have to abolish plea bargaining?
It should
Yep.
not be an option for
Ever, right?
a defendant to take at all.
Yeah, never. It's like if I abolish plea bargaining, I'm not like sometimes, but not other times. Or like on balance, we shouldn't have plea bargaining, or like we should abolish plea bargaining 51% of the time. Like no, it's like zero plea bargaining, or a bunch of plea bargaining that exists now, right? Okay, so I think that's all we need to do for abolish. But keep in mind, when you are negative, especially, that the affirmative stance is pretty extreme. The affirmative has to claim that they should abolish plea bargaining. If they recommend small changes to plea bargaining, that's not abolishing plea bargaining. You need to completely get rid of it. Okay, I want to discuss one more thing before moving on to the arguments in favor of abolishing plea bargaining and the arguments against it. So number one, and I'm gonna maybe turn this partially over to Lawrence for some suggestions. This topic is researching legal articles. Lawrence, why is it necessary on this topic to know how to get through legal articles?
Doesn't that question answer itself?
It was an easy question.
Because if you don't, your evidence is going to be bad.
Okay, so you're going to need to read a lot of legal articles on this topic because it is a legal topic. So I've written out some suggestions here for helping you comb through all the legal articles that the topic will be about. So, Lawrence, can you go through some of these?
Yeah, I guess. The first thing I want to point out is that all of you who are members of the National Speech and Debate Association have access to this great legal resource called Hein Online. We'll post the link down to it in the description of the podcast. But if you just go through it and sign in with your speech and debate password, you get access to a pretty big legal library.
Jessica, you want to hit me with that tip number 2?
So the second tip that I would have for researching legal articles is to understand the context of the court cases that have been ruled on. So for instance, something that's important for this one is the Brady case from 1979 that established that plea bargaining was constitutional by the Supreme Court. I think it's important to understand the circumstances of the cases because they really can lead to differing conclusions if they're not understood correctly.
Definitely agree with both of those. Really important on legal topics to get behind paywalls and get access to the best legal resources. And definitely agree with Jessica that understanding the legal relationships in the topic, there is no substitute for the Supreme Court. My piece of advice is that Control F is your friend. You will find Control F, by the way, is find for those of you that haven't listened to our research episode. Control F in legal articles is essential because legal articles are so long and a lot of them may not be relevant to your topic. A classic reason for this is that a lot of legal articles will be about whether or not plea bargaining is lawful or unlawful according to various Supreme Court opinions. And there might be not very much of it about whether plea bargaining ought to be abolished altogether or whether it would be good if plea bargaining is abolished. Use Control F to get to the good parts of those articles, and make sure that you search for the right things, even within your articles that you've already found. Using that can really open up a treasure trove of excellent content in really long articles. All right, when we return, we'll discuss, as we normally do, three affirmative cases, and then after that, we'll discuss 3 negative cases. Let's talk about 3 affirmative arguments. Now that we all have a good basis for the meaning of plea bargaining, how it works, and why people do it, and why people wouldn't want to do it, I think we can get very quickly into some of the arguments for it. Now, for every one of these arguments, affirmative and negative, we're going to discuss. We're going to discuss 3 things. First, we're going to discuss what is the argument. We want to give you all a good understanding of the argument and how it works and how it's warranted. Then we're going to discuss what are the possible value criterions that you can use in combination with the various contentions. And then we're going to discuss for each of these arguments 2 possible objections to this argument in case you have to debate it or in case you're wondering what objections that you would sort of want to respond to. So the very first argument, Jessica, if you would like to explain this, what I have here is strict retributivism / proportionality. What is the argument for proportionality on the affirmative on a topic that abolishes plea bargaining?
Sure. So the argument is that whenever there's no ability to kind of switch up what the sentence is or kind of bargain for something that is lesser, there's a higher chance, or actually there's like a definite chance that there will be some like that the defendants who are on trial will be sentenced and convicted if they are, based on whether they actually did the trial and what is in accordance with law. So this creates consistency within the justice system, and it creates sort of like a procedural justice that should be used in order to truly determine if somebody has to truly determine what somebody should serve for their crime. It's more okay. Wait, actually, it's fine.
Yeah. So basically, one of the versions of this argument is a trials good argument, right, Lawrence? Can you kind of explain, as Jessica did, or would you maybe summarize what Jessica said about trials and their relationship with proportionality?
Yeah, so if you're a believer in, just sort of justice as like you do the crime and you sort of pay the time or whatever,
Do your crime, do your time.
something like that.
Yeah.
Then you would sort of be a believer that the sort of system of a trial in which you're tried by theoretically 12 members of your 12 jury members who are your peers, who are unbiased and will attempt to render a decision based upon the best information available to them, and and then hopefully a judge who is qualified will give a sentence that is in line with the with the verdict and the crime that was supposedly committed. And you would think that that is sort of the optimal process by which we can determine someone's actual innocence or guilt, and if they are guilty, the sort of proper amount of prison time that is proportional to the crime that they have committed. And plea bargaining seems to undermine that in perhaps a few different ways. First is it perhaps causes people who are not guilty to plead guilty in order to, in case they are afraid that they might accidentally get found guilty and get a worse sentence. And we'll talk, I think, more about this in the second argument for the affirmative. But I think the part of plea bargaining that really sort of undermines strict proportionality and retributivism and is the fact where you almost always get a lesser sentence as a result of the plea bargain. So presume that you are really guilty. You should probably do the time, at least proponents of this viewpoint hold, that you should do the time that is proportional to the crime that you've committed. And plea bargaining means that by definition you're getting less of it, and that seems problematic.
Okay, so there was kind of a bunch of different things to unpack in there, and I want us to have a clear understanding of what it is. So proportionality, roughly, is the idea that when someone does something, the response should be appropriate to that something, and in terms of severity and punishment. So, Jessica, can you give an example of just like a wildly disproportionate punishment? Can you give an example of where a punishment is really severe for a crime that should not be, is not so severe?
Yeah, sure. So if anyone's seen like Les Mis, the main character steals a piece of bread and gets put into jail for like a very long time. That's definitely not proportional.
Les Mis reference, hashtag Mr. Herzig. He'd appreciate that. Shout out to you. And if you know Mr. Herzig, make sure he listens to this podcast. So yeah, steal a piece of bread, get thrown in jail. Not proportional at all. Getting your hand chopped off for stealing gummy bears, also not proportional, unless those gummy bears were made of gold. So Lawrence, can you sort of talk about the flip side? What would be an example of a proportionate punishment in the other direction? So let's say the crime was really severe.
Yeah, commit like first degree murder and like, run over a bunch of kids in a school zone and you get like a $20 fine and
Run over a bunch of kids. That got even darker than I was expecting. Jeez.
I mean, what did you expect from me?
Fair enough. Okay, so yeah, proportionality says both of those are wrong, and sort of what it's kind of looking for is the amount, the severity of the crime, and then you match the punishment related to the crime with that. Now, as Lawrence said, sometimes there should be no punishment at all because you didn't do anything, right? So in that sense, plea bargaining is bad because it could encourage potentially potentially innocent people, and it could, coerce them into accepting guilty pleas. And as Lawrence said, we'll get into that in a little bit. But It could also be that whatever your crime is, you get sentenced for less than you deserve as a result of that, and therefore justice is not served. So one kind of thing that I wanted to maybe talk with you two about. So one of my understandings of proportionality is kind of like an equality argument. So let's talk about justifications for proportionality. A lot of this stuff will kind of double as criterion arguments, although the criterion will usually be something like strict proportionality or strict retributivism or retributive justice or something like that. But I kind of wanted to go through with you all some of the philosophical ideas behind why you would want proportionality, why you would want a strict retributivist thing. So number one, I want to talk about equality. So the general idea, Lawrence, correct me if I'm wrong, is that if you and somebody else both do the same thing, then someone should not get punished more or less than somebody else. So that if two people both commit a more or less identical crime and one person gets a less severe sentence, it is sort of unequal, it is sort of unfair to that person who gets the bigger sentence.
Yeah, sort of the justice is blind thing. All offenders are treated equally before the law.
Right. So so in many senses, lack of proportionality kind of upsets that. There's also a kind of so have you ever read a retributivism case?
Yeah, so I debated the rehab versus retribution topic in 2013. So did say retributivism was good.
Yeah, at some point, I hope.
You only
Yeah,
had to say retributivism was good if you didn't really know how to properly negate on that topic.
Wow. Okay. Avoiding the topic 101 with Lauren Zhao next episode. Okay, so that means you also researched the topic, right? You kind of went into a lot of the reasons that people think that you should have retribution. Correct? Yes.
Yes.
So, so there's an overall problem in moral philosophy, and I wanted to get a sense whether retributivism, like how retributivism approaches that problem. So the problem is, why punish anyone? And it seems like that's kind of like a weird problem to have. But when you think about it, all that punishment is, from the point of view of the government, is inflicting harm to somebody. That's it. So there's an obvious problem with morally justifying that because, on balance, all that punishment does is it hurts somebody, So there's all sorts of ways, obviously, that you can justify punishment. One of them is a retributive way. Lawrence, what is the retributivist kind of thought about punishment? Retributivist as in retribution. What is the retribution argument for punishment?
Yeah, so we can distinguish the retributive view from perhaps the rehabilitative view or some other view of punishment that views punishment as instrumentally good. Instead, the retributivist approach would view punishment as sort of intrinsically desirable. It is valuable in and of itself. And I suppose there are various ways of justifying a retributivist theory. Perhaps you really think that deterrence is good, and that's a good side effect of it. But I would guess that the sort of best argument in favor of retributivism broadly is just that it is due upon people. That if you've wronged someone else, you have a wrong that is done to you, and that is sort of the way that we that's moral or just, and that's an intuition that these retributivists appeal to.
So the distinction that you drew between extrinsic and intrinsic justifications for punishment is exactly the right distinction, where retributivism says it is good to punish you kind of regardless of the consequences that would come about. Although this also does mean that your deterrence example is not an example of a justification for retribution.
Well, it would just be a healthy side effect that I think I think retributivists would think that deterrence is just like a nice little, thing to add on to their theory.
I think that most retributivists think that deterrence is irrelevant to their theory completely. Because whether or not a particular punishment would result in good consequences for law does not affect whether someone should be punished.
Well, yeah, certainly. I think they would agree that the sort of primary ethical principle motivating them is a sense of justice as retribution, and that a secondary benefit that doesn't necessarily have to result in deterrence is just deterrence.
Oh, so you're saying that, like, obviously Retributive doesn't think deterrence is bad,
Yeah, it's just like great.
right? But
It's certainly not. It's certainly a retributivist would not, for example, alter the length of punishment to fit to maximize deterrence, but I think would be open to the fact that retributivism does, in the long term, result in deterrence.
Okay. So yeah, if you want to think about it like that, if you can, under a retributivist sort of criterion about proportionality, your argument would be, though, that utilitarian arguments really don't factor into it, one way or the other. So I want to go to something that you said, Lawrence, something about how you kind of deserve what happens to you. So, are any of you kind of familiar with the Kantian argument for retributivism? Kind of like how that looks. If you aren't, I can go into it.
Jessica, I feel like you might know something about this.
Okay, if I'm correct, does it have to do with like hindering and hindrance about or something?
Sort of. It is similar to that.
Okay.
Like, isn't his argument just like whatever evil you inflict upon some other person, you inflict it upon yourself? Like, that's the quote or something like that.
It's very close to that. The argument is like kind of that when you do something to society, you kind of endorse that thing because you are willing the maxim that it is acceptable, but you have kind of broken the rightful legal condition around law, around the law, and therefore kind of it is only appropriate and in fact sort of required for the government to will your maxim back onto you. So therefore, if so for example, if you commit a violent crime, one of the maxims that you have willed, so to speak, is that you are sort of justified to other people that you endorse kind of modes of violence. And in many ways, that creates a justification for retributive punishment. Because what that says is, sure, you have no possible objection to the state using violence on you by, for example, throwing you in prison, because you've endorsed that violence is already acceptable. Now, of course, all that proves is that strict retributivism is not wrong. It doesn't by itself prove that strict retributivism is right. The part that is right is a little more complicated. And by the way, you should all feel free to research Kant's arguments in favor of retributivism. The phrase that you all can research is I'm gonna like spell it because it's like a random set of Latin words, and in fact, I'm gonna have to spell it out for myself to make sure I don't forget it. So the name of the phrase is lex talionis, spelled Lex space Talionis. That's lex, and then Talionis. So lex talionis is basically just the principle: an eye for an eye. If you do something to someone, you get that thing done to yourself. I don't know if Kant uses that term, but he might. And his argument is basically that if you do a wrong thing, then, and you kind of break the rightful legal condition in your society, it is only appropriate for the government to rectify that condition. And it can rectify that condition any way that it wants that you have already willed is acceptable. Did that make sense to either of you, Lawrence or Jessica? I can go into more detail about it if necessary.
Oh, I think that was good enough.
It's good enough. That was like a resigned thing. All of this is online. You can easily find it. Oh, I actually remembered what one of the other arguments for it. So Lawrence will have to suffer through it more. So one of the arguments for strict proportionality is the idea that when you so now I remember, this is actually one of the main arguments. So one of them, and by the way, all of this is in a book called by Force and Freedom by Arthur Ripstein. All of this is there. Or at least in an article that he wrote about. Arthur Ripstein wrote about retributivism, proportionality, and law. So I highly recommend looking up Arthur Ripstein's stuff. And anyway, so his argument, which is a summary of Kant, is the argument that when a criminal violates the law, what they are saying is the law applies to everyone except for me. And by that, I mean I'm creating an exception of myself. I am saying the law applies everywhere, but it does not apply in my case because I'm breaking it. And in Ripstein's view, the only way, according to Kant, for that to be made up is for the state to kind of will that maxim back onto them in the opposite way, and to say, in fact, you said that the law applies to everyone but you, but instead we are going to apply the protections of the law to everyone but you. You no longer deserve the protection of the law from things like going to prison, for things like state violence. You no longer deserve the protection of that law because you have willed that it no longer applies to you. So we will will that back onto you. Did that make sense, Lawrence or Jessica? I say or
Yes.
because it may not have. So okay, so that's enough Kantian retributivism arguments for one day. But so I want to get into the last retributivist justification. And I'm going deep on this because I do think that it is a very good affirmative argument, and I kind of has very philosophical basis. So I wanted to get a sense of what it is. Jessica, what is your understanding, just like colloquially, if you were to just like talk to, I don't want to like make, if you like, one of your parents, if you were just going to talk to them and you're like, why do you think that people are punished? I'm just wondering, what do you think they would say? If you're like, hey, this person like stabbed, 5 babies, and then you're like, hey, dad or mom, why should this person be punished?
I think my parents would say one of two things. They'd either say first that it was problematic on a moral level, that whenever somebody has like committed an atrocity, they should not be able to just get off with and do that. The second thing that they would probably say would be to prevent them from doing that in the future. So likely they would not enjoy going to prison for stabbing 5 children. And if they ever were given the opportunity to even come out of prison, they probably would not do that again because of how unenjoyable being in prison was.
So I think that they would definitely say both of those things. And let's talk especially about the first one. So the first one, your parents said that they would want something really bad to happen to the person that did the bad thing, almost on the basis of just how bad it was by itself. So the idea is that person deserves it. They are an immoral person. They deserve all of the harms that come to them. So, I think that is a kind of retributivist argument at its very base, but it is more related to vengeance. Lawrence, can you kind of just Lawrence, do you agree with me? Do you love me, Lawrence?
Plead the fifth.
Plead the fifth. Legal topic. Yay, law. Vengeance as a general thing. Lawrence, if you wanted to put vengeance in a specific light, if you wanted to make a moral argument about vengeance, when people talk about vengeance for what? For who, and why is that important?
I assume most vengeance is victim-centered, which is when
Right.
you punish someone, it's for the sake of enacting a harm upon the offender for the purposes of satisfying the victim in some weird form or fashion. I mean, I don't really understand why people do it, but whatever.
Well, yeah, I think that I think you're exactly right. And I also think that you're exactly right that it's really weird if you think about it too hard. Right? But I do think, and correct me if I'm wrong, this is the argument that most people in society would make, right? It's like the victim has earned it or something.
There are other justice-centered approaches which really center the victim, and their sense of well-being as a primary concern in the punishment concern. So, like, restorative justice really cares about, for example, the victim, but they care about it as the victim being compensated and or like having the situation restored to its, to what it was previously. And retributivism is just like, nah, let's find a formalized institution by which we can inflict some degree of suffering and pain upon the offender.
Yeah, definitely it's like infliction of suffering, good because of the really bad thing that they did to the victim. And the situation that makes it a little strange, as Lawrence kind of alluded to. If this was kind of like a civil case, then it would make a little bit more direct sense. It's like, you did something to me, and as a consequence, you should pay me $20,000. They're like, fair enough. But the difference is, like, if I murder someone and the government is like, okay, we're going to put you in jail for 30 years, it's like there's a sense in which that doesn't really do anything for the victim, right? Like, nothing really happens to the victim. The victim doesn't really benefit in any way, except that maybe they're happier. But if the person has been murdered, there also isn't even that. So it's like there's something weird about vengeance, but there is some sense in which the importance of the victim demands a retributive response, even if that wouldn't result in deterrence or not, right? That's what, like, a lot of people would think. Like Jessica, if I went to your dad, let's say, I mean, maybe this is like a psychological question, but like, let's say that I was like, hey, hey, Jessica's dad, if so, we have two options. One is we can convict this person that stabbed 8 toddlers to 25 years in prison. But if we do that, then burglaries will increase 5% in that county. Versus giving them 5 years with no increase in burglary. Or sorry, yeah. Let's say 15 years. Well, let's assume that they never commit another crime again. So 15 years versus 25 years. In either situation, they do not commit another crime again. In one of them, they get punished way less.
So in the 25-year scenario, there's still 5% more crimes outside of like the same person.
My point is that there are only two differences between the two worlds. In one of them, the person gets punished way more severely, but crime goes up.
My dad would probably say the one where he gets punished less severely and crime does not increase.
Really? Huh. Okay, so
I'll take this one though. My mom would definitely just be like, nah, they deserved it. Because my mom justified the death penalty to me by just being like, they deserve to die. Which, to some degree, that really captures our retributivist intuitions on sort of a gut animalistic level, which is just like, perhaps they really deserve this punishment and they deserve to die. And so regardless of societal consequences, like perhaps a spike in burglary or robbery, they just deserve those 15 years in prison.
Yeah, I'm pretty sure my parents are utilitarians.
Yeah,
so
I'm about to say maybe because like my parents would definitely do the Lawrence thing, but
to be clear, this is not me.
Maybe Jessica's parents are just on a whole other level of like rationality.
No,
just like decision making.
That's my mom. I hold relatively utilitarian outlooks on punishment. I'm not nearly so principled as to punish someone extra for the sole sake of that punishment.
Yeah, but like I believe that definitely my parents would be like, you deserve that. You are going down. Okay, so we've talked for a long time about this one. Let's talk about some responses, and then we'll go through the next one. But that one was really complicated, and I wanted to come out of that section with a really good understanding of proportionality and how it works, and how you might want to justify it on a criterion level. Okay, responses. So number one, Lawrence, can you talk about the number one objection?
Yeah, so it's a little bit difficult to enact strict proportionality or retributivism if we don't really have a functioning justice system to begin with. And as we noted in the above part in the first section, where we're talking about how plea bargaining is used like 95% of the time, or something ridiculous like that. You could imagine that we've really only come to that high usage number because we, for some reason, think that it's really necessary for the functioning of a court system. And if we don't really have a working judicial system, it becomes pretty difficult to really mete out the punishments that are consistent with strict retributivism. So, if we don't have a working justice system, then we can't really access any of those benefits in the first place.
All right, and what is the second way of responding to proportionality?
So it seems that like strict proportionality seems to be very tenuous if it would slow down our courts by that much. Seemingly, if using the plea bargain still gives people some degree of punishment and still aims towards some level of proportionality, that good should be good enough. We shouldn't just try to pinpoint exactly like how much somebody should get, sacrificing the pragmatism of our justice system.
Yeah, and what one other thing that I think is associated with this is that strict proportionality is also extremely hard, right? Like are two crimes ever really the same? Rhetorical question. um and also like there's kind of sometimes there's difference between legal proportionality and moral proportionality. How do you know that the law is really assigning the appropriate proportional punishment? Maybe letting people off easy is the best thing. Okay, so we've spent enough time on proportionality. I want to talk about the next argument. This argument is racism and oppression. So, Lawrence, what is oppression and what does this AF case say?
Oppression is difficult to define. I mean, like, there's this great article by Young that is like the 5 faces of oppression, defines it differently. But basically, it's just like unjust treatment or control, or being subject to a cruel exercise of power. Typically, oppression implies this sort of connotation that some larger force is bearing down upon you, and it's very difficult for you to resist because it is sort of this force that is difficult to withstand. So typically involves power and the exercise of that power in a generally arbitrary and cruel manner. So what is this argument concerning racism? Well, the first part of this argument I don't think is necessarily racism based, but we just notice that the impacts of plea bargaining do result in sort of racist consequences. So we start from this sort of simple idea that plea bargaining could potentially result in unjust sentences and unjust convictions. So imagine people who are pressured. Apologize. Imagine people who are pressured into pleading guilty in the criminal justice system because they know that a trial takes a lot of money, and money that they don't have, and time that they don't have, and they know that if they get convicted, that sentence could be really, really long, so years in prison. And so you can imagine for why poor individuals, or even just not wealthy individuals, would choose a plea bargain. Even if they're not guilty, it seems to make sense that they would take the plea bargain and shoot for that lower sentence. And this manifests itself in pretty disparate manners, where those who are primarily of color and on the lower income scale will tend to be pressured into taking these plea bargains, and they're going to be the ones who end up incarcerated. And there's a lot of people, specifically a few authors like Michelle Alexander, who really think that the linchpin of modern mass incarceration is plea bargaining, because all of these poorer people of color are sort of forced in the criminal justice system because they can't say no. They have to take the plea bargain in order to have, because it's rational from their perspective, and then they end up in prison, and a lot of them end up in prison.
Far too many of them. So, in what sense is that, Jessica? In what sense is that really like oppression, and in what sense, what kind of tangible bad effects does it have on real people?
Sure. So this is oppressive. First, it puts an unfair amount of pressure onto people of color and people in poorer communities to just submit to like their plea bargains and their sentences, which tends to funnel them into like the prison systems at a lot higher of a rate than richer communities who can actually afford trial costs, or people who tend to have a more privilege in society. And this manifests it in the lived experiences of people of color, because it tends to decrease like the amount of trust that they have in like the legal system as a whole.
So how exactly would you research this kind of argument?
Well, it's not that difficult if you sort of just Google plea bargaining and like injustice, racism, whatever you want to stick on the end there. There's tons of news articles that are citing wider studies, including ones that just came out this year that talk about the sort of disparate impacts that plea bargaining has on primarily communities of color. And they talk about the way that plea bargaining is used in along pretty clear racial lines. I'd also like to interject one random thing: is that independent of this racism argument in here, there's a separate moral question, which is like, it's especially worse that it's racist, but even removing that factor, there seems to be an injustice here because their criminal justice system ought not, I think, to all of our intuitions, put people who are probably innocent behind bars and unnecessarily restrict their freedom with coercive state power by locking them into a segmented part of, into a segmented population from which they have functionally no freedom. And so even if this occurred in completely race neutral lines, we would still find this to be an injustice, a travesty, because of that sort of undue violation of freedom. And it's just made markedly worse by the fact that it does tend to occur along racial and income lines. So, sorry, back to the researching part. Yeah, it's not that difficult. Tons of people write about it. This was a really popular subject of discussion back in like the 80s as well, where it wasn't really necessarily race focused, but they talked about the sort of pressures that plea bargaining created to accept guilty pleas unnecessarily. And it's actually the subject of a lot of interesting economic models concerning game theory, and where they confirm using empirics that, like, in fact, lots of innocent people will plead guilty, and those people tend to be of the minority persuasion.
Of
but
the
yeah,
minority persuasion.
Yeah, this is not. This one's really not that difficult to research. I mean, like you find these within the first couple of pages of Google, even if you're just Google like plea bargaining, like abolish, and it's gonna be up there.
Yeah. Honestly, quite easy to research. Jessica, what are the criterions that you would associate with this case?
Yeah, so I think there are a lot of common ones that are currently being used in Lincoln Douglas debate, such as minimizing structural violence and like minimizing arbitrariness, or just any framework that's really based upon like maintaining the equality of people.
Yeah. So all of those would work. Justifying sort of the fundamental equality of people obviously means that oppression is bad, because oppression says that people should have access to disproportionate goods on the basis of arbitrary factors. That is unequal. So oppression is bad. So one important thing that I want to mention, and I'm going to ask you all's opinion on this. So we're going to get to this later, but obviously the negative arguments on this topic are really utilitarian. So even though you could theoretically have a utilitarian criterion, I really don't recommend it, because having a criterion that is more related to oppression will greater allow it to escape negative arguments. Do you all agree with me, or do you think that reading utilitarianism is a better idea, or something like that?
When I debated and in Oklahoma, I very rarely read utilitarian criterions on the affirmative, because, as you mentioned, especially on this topic, it just opens. It basically means that there is no framework debate anymore, because the negative is obviously not going to contest it. Most of the sort of more principled arguments, for example, like strict proportionality and retributivism and like protecting the innocent, et cetera, most of those are affirmative arguments, and very few principled type arguments on the negative. So I would recommend not reading a utilitarian criterion on the affirmative if you're trying to be a little bit more strategic and avoiding all of the negatives arguments from applying. But, you just don't want to have a criterion debate, then sure, why not read utilitarianism?
Yeah, I would agree. I think a utilitarianism framework that is strictly about just like, the cost benefit analysis, how many like lives are like lost or saved, that seems to be like inconsistent with the benefits of like using a plea bargain, even under like this racism or structural violence. These racism and structural violence arguments, those just don't seem to be encapsulated as well. And similarly, I think like the really like strictly utilitarian arguments seem to be premised on some very unlikely scenarios, especially on this topic, that I just think the negative will have like a higher degree of credence on.
Yeah, definitely true, and you shouldn't give them any credence that they do not otherwise deserve. That would be unequal and disproportionate. Um, so let's talk about some responses to this. Lawrence, what's the first response that you would make to this argument? And we kind of talked about some of the utilitarian arguments, even though we haven't gotten to the negative quite yet. So how do some of those arguments impact back to this case?
Right. So think about all of the crimes that go unpunished if we get rid of plea bargaining. So it seems unlikely that every single one of the 95 to 97% of those who currently take plea bargains are guilty, but it also seems unlikely that all of those people are innocent. And I would assume that at least half of the people that take plea bargains are probably guilty. And so those people would most likely go on to commit more crimes if they were not tried, because, you know, if you get rid of plea bargains, that's going to massively increase the number of trials. Most likely not going to be that many trials. So a lot of people are just going to go unpunished for those crimes. And those crimes are likely to occur in the same low income neighborhoods that would most likely impact the same people that the affirmative is talking about. And there's a good reason to believe that that crime might in fact be worse than the impact of plea bargaining, or so the negative should argue.
Um, So I want to talk about that on a slightly different axis. So to be clear, it's not just that it is a utilitarian impact and that utilitarian impact outweighs the oppression impacts. Maybe I misheard you, but can you kind of, maybe maybe just like explain exactly um how those kinds of things like inefficiency and crime cause oppression specifically?
Well, it seems likely that inefficient court system and the increased crime as a result would result in the same sort of material harms that imprisonment or like a failed justice system would, as a result of plea bargaining. So like, you know, if you think that like getting stuck behind bars for a bit is bad, imagine like another robbery in your town or like another murder in your neighborhood or something like that. And these things seem to impact disparately within communities that are affected, like the same communities that the affirmative would claim are affected by plea bargaining.
That is definitely right, and also directly related. So Jessica, what is the next argument that we
Yeah,
have
so
here?
there needs to be other ways to fix the problems of racism and structural violence without abolishing the plea bargain. Seemingly abolishing the plea bargain doesn't change the fact that like trials are still going to be more expensive and that people are still going to have implicit racial biases. So seemingly by abolishing the plea bargain, uh, the people who are poor will tend to have like lower quality lawyers and just end up being convicted for crimes rather than being able to take the plea bargain for a shorter sentence. So seemingly we should seek some other alternative to abolishing the plea bargain that would avoid these harms.
Yeah. So yeah, a lot of these problems, as you say, are really soluble without abolition. Is basically what you're saying, right?
Yeah.
Okay. So let's move on to the last affirmative argument. I will say that both of those arguments that we just said really are like the major affirmative arguments, the major types of affirmative arguments. So I have this here as so the third affirmative case that we have is constitutionality, and this case angers me, so I want you to introduce it, Lawrence.
Oh goodness. Well, it angers me too, mostly because if I have to sort of judge this argument, I'd rather not.
Angry react.
Why did we put this in here? Is it just to tell people to not run it? Because I'm okay with that.
Well,
Um, like, there's a good reason to believe that plea bargaining is unconstitutional. I mean, there's legal scholars that write about this, but functionally, what it does is it causes people to waive their, guaranteed right to a trial, which is a constitutionally protected right. And given the unnecessarily coercive environment that plea bargaining occurs in, a lot of legal experts are on the fence about this, but they seem to be open to the argument that it in fact is pressuring people to lose one of their constitutional rights, and that's problematic. Yeah, that's basically the argument.
So basically, these are legal scholars, and those of you who are unfamiliar with the literature surrounding law, people argue, legal scholars, scholars in colleges and universities of law, will argue with each other about about different ways that the Constitution should be interpreted. And you know, because I guess in the case of constitutional law, yeah, about the way that the Constitution should be interpreted. And the idea is that the Constitution has some has various provisions, and currently the Supreme Court says that that there is some meaning out there, or the Supreme Court doesn't talk about it at all, leaving it up to debate. And legal scholars debate with each other about what is the appropriate reading of the Constitution, and how, if the Constitution were interpreted in the right way, what would it look like? Now, at its most serious level, when the Supreme Court gets a hold of something like this, or other courts, they will make the same judgments as scholars do, except those judgments will obviously be binding because they are the law. Whereas a judgment, obviously, in a legal article is not itself binding, but is the same sort of decision that a court would make on the basis of, this is illegal, therefore we shouldn't do it. So, what I kind of want to do is I want to introduce the most charitable version of this argument. So there are two versions of this argument, and one of them I really don't like, and one of them I think is a little more justifiable. So the first one and the one that I don't like is the argument that plea bargaining is unconstitutional and we should reject all things that are unconstitutional. This argument uses the same reasoning that I discussed before in all the law review articles. You would say, these articles say that plea bargaining is unconstitutional. As a result, anything that is unconstitutional should be rejected, so plea bargaining should be rejected. I don't like that argument. I'm going to explain why in a minute. The other argument, or I'll just do it right now. Why make Lawrence and Jessica wait any longer? Actually, I already told them why I don't like it. Actually, wait, no. We should save that for the responses section. Sorry. Okay, so the second version of the argument is to say that if something is unconstitutional, then parts of the Constitution cut against that argument. And therefore, things that part of the Constitution, even if the thing is technically constitutional, if the Constitution was written to be a very important document that governs behavior and is mostly accurate about what things are right and wrong, which is why it's survived for so long. And if that's true, we should follow what the Constitution actually means instead of just what the people in the Supreme Court says it means. And therefore, if something is probably unconstitutional, it should probably be prohibited. Does that make sense, Lawrence, Jessica?
Yeah. Okay,
so the possible criterions are obviously consistency with the Constitution or consistency with constitutional principles. I think I like the second one better. So the reason that I like the second one better is this first response, which I'm so angry about this, so I'm just going to blurt it out before you all even have a chance to steal it from me. So the first obvious response is, if your opponent's argument is that plea bargaining is unconstitutional, they are wrong, because plea bargaining has been interpreted by the Supreme Court to mean that it is constitutional. And the Supreme Court is the sole arbiter of what is constitutional and what is not, which means that if I or some random law professor gives a bunch of arguments why, for example, trials are unconstitutional, that doesn't matter because the Supreme Court has ruled that it is. So even if I present a 1,000-page long document, that doesn't do anything and I'm wrong. The Supreme Court interprets the Constitution. So if your opponent's argument is just that the Supreme Court is straight up unconstitutional, you should level them, and by level as in the same way you would level a house, just knock them down physically. And level them by being like, the Supreme Court interprets the Constitution. The Supreme Court says plea bargaining is good. There's no debate. Now, the other version of this case that I said kind of gets around this objection because it says, sure, the Supreme Court maybe says that it's accurate, but we should follow the dictates of what, the old versions of the Constitution say, and following those dictates means that even if the Supreme Court says that it's true, we should still reject it. But whatever. I'm done talking about this. Lawrence, what's the second response to the constitutionality case?
Yeah, the Constitution isn't the moral law. At one point in time, it allowed slavery. It was written a long time ago by some people who we, for some reason, think are infallible because they were the founders of the United States. But when in reality, a bunch of rushed old white guys in a room trying to put together a, constitution for our new country that we were kind of creating haphazardly. So, maybe not the moral law of the land to follow, because as it turns out, an unjust law is no law at all.
Interesting. So I like the first part of what you said. The last part of what you said made me pause, and the middle part of what you said was just like an unpatriotic diatribe against our founding fathers.
It's nothing against the founding fathers, just more like
They're just old white guys that can't write.
well, more like they were brilliant for their time, and the Constitution was, in fact, a marvelous work of writing. But to presume that it was the infallible document that so many people think that it is seems a bit silly, especially not when it comes to legal matters, but when it maybe comes to like the moral side of things,
Yeah, because that's the real argument, right?
Yeah.
The real argument is just that, like, obviously there are things that are immoral that are laws. Like, that is possible, right?
Yeah, and the Constitution is not immune to that criticism, is basically what my point was in that long anti-patriotic diatribe.
Yeah. So my personal advice to you is that on a lot of the circuits that we debate, like for example, on the Central Florida local circuit, I would never advise my kids to say like the Constitution is bad and old and white, because
Well, I wouldn't recommend that either, but
the judges would be like, absolutely not. How dare you? Hashtag founding fathers. Hashtag Constitution.
which is precisely my criticism, which is that people hold it to such a high esteem relative to what it was at the time.
Right. But of course, you can't change that about your judges. So what you should do instead is say, yeah, the Constitution is good, but the Constitution is obviously not the only thing that determines morality, which is why civil disobedience was good, why there was the Civil Rights Act, and why black people are not slaves in America any longer. Because even though the Constitution even though there were Supreme Court cases saying that they were in fact property, that happened in the past.
All right, I think we're
spent an incredible amount of time on affirmative arguments. When we come back, we'll talk about negative arguments. All right, we got 3 negative arguments, and we don't want to have you here for that much longer. Biggest negative arguments: efficiency would destroy the criminal justice system. What is this argument, Jessica?
Sure. So given that such a staggering percentage of cases are plea bargain, literally like 90, 97, 95%, if all those cases were to truly be prosecuted, that would literally explode the criminal justice system. So many trials would go to court that like nothing would eventually happen, that there wouldn't be any possibility for like such proportionality or retributive justice, because the courts would just be like so backlogged by the sheer amount of cases that they now have to take on.
Yeah, so yeah, exactly right. We talked about this at the very beginning of the episode. So, Lawrence, what is court clog, quote unquote? When people made this argument last year on the qualified immunity topic, it makes so much sense on this topic. What is what is the phrase court clog if someone uses it in a debate round?
I mean, like court clog, just like this random phrase that like I'm pretty sure if you Google it only turns up debate results, but it's just like a shorthand way of claiming that like, hey, the courts are backlogged, i.e. they have tons of cases within them, and adding more cases to them means that prosecutors, juries, and judges can never get through all of the case loads that they have before them, and as a result, a lot of cases are either going to wait around forever or just simply never get tried, and that seems problematic.
Alrighty, that's true. So the possible criterions I have here: utilitarianism, greatest good for the greatest number of people in terms of happiness and unhappiness. What is pragmatism? Whoever wrote it.
I'm pretty sure that was Jessica. Was that?
Yeah, just Jessica. What is pragmatism in the context of this resolution / criterion debate?
Okay, so it stems from the word like pragmatic, which means to like do things in a sensible and realistic way. that are like very practical rather than grounded in theoretical reasoning or moral considerations. So in context of this negative argument, the most practical thing or the most efficient thing to do would definitely be to maintain the plea bargain, even if it caused some moral harms.
Yeah, exactly. Sometimes you gotta make the tough decisions for moralities. Um, and okay, responses to this argument. Lawrence, first one, go.
So presuming that you don't adopt a utilitarian standard to evaluate the, ethics of abolishing plea bargaining, you could make some principled argument and claim that regardless of its consequentialist effect, that there's still some moral imperative to abolish plea bargaining. So for example, if you think that it's problematic because it's unconstitutional, well, most people who are legal scholars wouldn't really care that much about, if you overloaded the court system, if the practice was itself unconstitutional, or if you really were about strict proportionality, you would accept the sort of overload of the courts as just an unfortunate consequence of maintaining this like really defining feature of justice, which is like strict proportionality and retributivism. So it's still moral, I think, is what we have it tagged as here.
Yes, and I'm gonna go into the number two. So this argument is basically the overall negative argument is that the criminal justice system cannot handle a large number of cases that exist every day. So one of the responses to this argument is a kind of an affirmative. You could call this an impact term. So basically, what this says is if it happened, the United States legal system would have to adapt to that change. It's not that the United States legal system would all of a sudden decide to just no longer work at all, which means that what would probably happen as a result of that is that less crimes would be prosecuted as a way of kind of accommodating that change. And what that might mean is decriminalization or other crimes not being prosecuted as much, or even some things that are currently labeled as crimes being not labeled as crimes. That might the affirmative argue, especially if on the affirmative you're making the oppression argument. One argument that you can make is that there are a lot of laws that are kind of enforced in a really bad way, and that are really not good for America. Classic example of this: the drug war and the effect that those laws have had on people of color. So one argument that you can make is the fact that there will be a big change to the criminal justice system in terms of laws is actually a good change because that change facilitates a less oppressive legal system. That is one one potential argument. Obviously, there are tons of negative responses to it, but I would definitely say so there are kind of two components of the argument I just made. I would definitely use the first one. It's up to you whether you want to use the second one. Definitely say that the legal system would not just roll over. It would have to make changes to accommodate itself. Those changes are good because currently the plea bargaining system stinks. And you can also add that some of those changes might be the decriminalization of certain crimes, which shouldn't really be illegal anyway because they're producing a lot of bad results. All right, let's go into the second negative case. This argument is crime. My understanding of this argument is that it is very close to the kind of in exchange for testimony part of plea bargaining. Lawrence, am I right or wrong about that? / what's the argument? / help me, please.
Yeah, you'd be correct in that assumption. So this is distinct from the crime argument that I made earlier as a response to the sort of structural violence racism type affirmative, because that argument was just about not prosecuting crimes, which is a result of a clogged court, which is the argument we just talked about a second ago. This is instead the argument that plea bargaining is a necessary part of any sort of crime prevention and reduction strategy, specifically when it comes to like organized crime. So the basic argument here is that plea bargaining is a useful tool in the law enforcement toolbox for prosecutors to offer to lower level criminals in exchange for testimony to secure other convictions against higher level criminals. And I think we talked about this at the top as well when we were talking about the motivation for offering plea bargaining. And there's some evidence to indicate that in certain cases, there's like this law called like RICO. It's like, do you know anything about that, Martin?
Racketeer influence and corrupt organizations, I think.
Yeah.
That's
Yeah.
awesome. I was gonna say
Woo.
racketeering and then just be silent.
Yeah, yeah.
There's like a
Um,
Jake about it.
The only reason I know about it is because of the Dark Knight movie. They mentioned Rico once, and I'm like, racketeering. That's literally the only reason. Actually, just the only one.
yeah. So like that. So RICO and plea bargaining, for instance, like there's a strong connection between them, and you can research that on your own time. It's quite interesting. But so corporate fraud, for instance, all of those things are organizations that plea bargaining is just a useful tool. So the negative would argue for chipping away at those organizations that do bad things.
Yep. So okay. What kinds of cases, are you mostly so like are we talking like the mob, stuff like that?
That's I think in popular media the most popular,
The
like the
most
most
popular
popular.
media?
Yeah, in popular media, the most like popular portrayal of plea bargaining is when like it's used to secure testimony against like a mob boss or something. It's like, you know, tell us, like, give us evidence to bring down your boss, and we'll drop your charges to like functionally zero and give you witness protection or something like that. I actually haven't watched a law procedural show in forever, so I don't know what it sounds like. But basically, that's what it is. Um, which is weird because the media doesn't portray plea bargains usually, since 95% of trials are plea bargains. But whatever. Yeah, I
What
think
if there was just like a procedural drama, which was just like a lawyer sitting in his office all day, and someone comes in for a 5 minute for the to their court appointed attorney, and like they just like come in for 5 minutes. They're like, "Here's the case," and the lawyer's like, "Yeah, you should plead guilty and accept whatever they give you," and the other person's like, "K," and then that happens for the whole day.
yeah, and to
Which
be
is like kind of like actually like I had to read a book as a result of a class that I took, and like man, like that is like actually what happens.
yeah.
It's so scary.
Well, and there's one other weird thing is the media will like to portray these plea bargains as going to like low level criminals, and they exchange their bosses up in hand for the testimony. But in reality, the most publicized stories in the newspapers are, for instance, of mob kingpins who will take a plea bargain and give up all the people below them, right? So like John Gotti, who is like the acting boss of the Gambino crime family, he just like rejected a plea bargain that to avoid having him avoid sending other people of his to prison. But like there's this like but there are other mob kingpins who will like take the plea bargain and they'll get like all of their charges dropped and give up like the rest of their organization, and they live a cushy life, relatively speaking, just because they have a plea bargain. So it works both ways.
Indeed. Okay, so possible criterions: utilitarianism, pragmatism, responses. Number one, Jessica.
Okay. If the affirmative is reading a structural violence or racism based case, seemingly poverty and like the affirmative's impacts are the root cause of crime. They're what caused the for people to need to pursue criminal behavior in order to survive. So it seems to uh, I guess, precede the negatives argument about minimizing crime, in that I guess reducing the AF's impacts would be a kind of a precursor or a way to also minimize crime in potentially a more effective way, as argued by the affirmative.
Yeah, definitely. It solves the root cause of crime, because like one things that these cases don't really ask is like, or that they like kind of assume is like, the way to stop the crime is you just catch all the criminals. Where the problem is, quote unquote, the criminals is just like everyone, right? So it's like the criminals. If the criminals just refers to everyone, because basically there are new criminals, coming up every day, then you never quote unquote solve any crime. Whereas the best way to solve crime is to make sure that people aren't trapped in poverty in their communities and generations, and the affirmative does that. Okay, so Jessica, you wrote this next argument as well. Can you kind of explain it?
Yeah, so abolishing the plea bargain kind of increases the amount of cases that will go to court. So it's easier for people to get convictions that way. Like statistically, if there are more cases that will go to court, seemingly there's some degree of those that will have convictions in a way that is more just or more proportional than simply just abolishing the plea bargain, or than maintaining the plea bargain.
Yeah, so in that sense, it kind of decreases crime. Um, one other thing that you can kind of focus here is you can also just like say that this argument is wrong. Like, does plea bargaining actually reduce crime? Does it maybe it increases crime. Maybe like increases in testimony are bad. Maybe there's some reasons why it's not. Don't take the negative at their word. And another thing is that like it's not really like plea bargaining in exchange for testimony is definitely not the most common form of plea bargaining. So it could be that whatever the affirmative is talking about kind of outweighs this anyway. All right, Lawrence, you come up with this. So this is the third negative case, defendant choice. I don't. What is this argument?
Lawrence? So I mean, there are other negative arguments, but I think we like talked about most of them as like at least minimally responses to the affirmative. So this one's sort of the typical defense of like the charitable defense that the prosecution will offer for why plea bargaining is good, which is that it just gives defendants a larger array of choices to make. And what it does for them is it reduces the uncertainty that defendants face, and it likely results in more individualized pleas for not pleas, more individualized sentences, for the specific individual, which is like most consistent with proportionality. And so basically, most defendants probably don't like the uncertainty, and so providing the option to take a certain outcome, which is, yes, you go to jail, but you go to jail for a much shorter period of time. That, as opposed to maybe going to jail, but if you do go to jail, going to jail for a really long period of time, it seems to just offer a choice to the defendant that seems to be, really good for the defendant. So the prosecution will say. I also would like to know.
Is it that the choice? Sorry to interrupt, but is it that the choice is good for the defendant, or is it that it is good for the defendant to be able to choose?
Why not both? Like I would guess that in a lot of circumstances, it just so happens that the choice would be good for the defendant to choose. But I think the prosecution also, people who are offering this defensive plea bargaining would say, well, merely having the option available is good as well. Just simply because it expands defendant choices.
Basically, I want to kind of hit on what a criterion you would want. So would you just have a criterion of like giving, autonomy or whatever, and then just be like, plea bargaining lets people choose and is therefore good, regardless of whether people would always choose for a more severe punishment?
Maybe not so broad as autonomy, but maybe because some people will offer plea bargaining and defend it from the perspective of protecting the defendants. So we could just sort of like protecting defendants' rights, things like that would, I think, be also viable criterions.
I mean, how is wheeling and dealing a right?
Well, like just protecting, maybe not their rights, just protecting defendants to some degree. I don't know. Good question.
I think that so in my view, the best version of this argument is kind of just less, severe sentences good.
Yeah.
And so the important point is not really that they could choose to do it. The important point is just that in a world with plea bargaining, there are more guilty pleas, and there are less severe sentences on average than if you didn't have it.
Yeah.
And so, therefore, this argument is kind of the opposite of retributivism, in the sense that retributivists would be like, let's punish people as much as possible. And this argument is kind of just like, we should punish people as little as possible. I can actually envision both a deontological and sort of a criterion-based argument, and a utilitarian or consequentialist-based argument for this. And the consequentialist argument is obvious: being in prison is bad. And the deontological argument is a little more just like, punishment is immoral in general, and therefore we should have, as little of it as we can. Right? I mean, like,
Yeah.
I mean, Jessica, do you think that that's kind of like a viable argument? If my criterion was just like something related to like, not inflicting any unjustified harm, and then like your point is like violence for punishment is unjustified, therefore we should punish people as little as possible. Plea bargaining allows for the minimal amounts of punishment.
Yeah, I think that's fair. I also think like arguments about like mass incarceration can link into like structural violence based frameworks if that's what a negative will choose to read.
Yeah, what is mass incarceration real quick?
Sure, it's the tendency to put so like a large amount of people in prison, something that is disproportionate to the amount of people who really deserve to be there.
Yeah. So I think that is absolutely right, as well. So let's talk about responses. So what's the first one, Lawrence?
Um, yeah, so the issue with this is it's mostly a theoretical defense of plea bargaining, and why it's probably not a super common defense anymore, which is that like evidence is pretty good at showing that like the pro offering of more choices generally leads to suboptimal outcomes in these circumstances. Theoretically, it's supposed to lead to optimal outcomes by reducing the amount of sentences that occur, but it but it only really creates suboptimal outcomes. So a good example is like a study which asked students to take a test, and all of the students, who even when they didn't cheat, were all accused of cheating after this test was over, and then they were offered this option: either, like plead guilty and basically we'll just like not count anything against you, or plead guilt or don't plead guilty, but if we find you guilty of cheating, like there's gonna be this fine, there's gonna be like other punishments, blah 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 blah. And turns out almost everyone selected that they were guilty even when they weren't, because of this option that was available to them, and it really led to these suboptimal outcomes. In the criminal justice system, it leads to more sentences that are unnecessary because innocent people will admit to being guilty as a result of this, and so it really hurts them and gives them more sentences and longer sentences than they otherwise would deserve.
Mm-hmm. And I think that the second sort of easy argument is, as I mentioned, this argument is the flip side of a retributivist argument. If people are running this argument correctly, what they're saying is basically that there should be as few people in prison as possible, and you, as the affirmative, can just say no, that's not right, right? In fact, some people are in prison because they deserve to be in prison. And some people should be in prison for a long time. And if someone is in prison, versus 20 years, maybe that person is in society for another 20 years. So either because they deserve it or that it has bad consequences. You should that this argument is actually just wrong. That this argument says plea bargaining leads to less severe sentences on average. Then this negative case says that's bad. The affirmative case can say that's good. So, and just like really quick, one argument that they could also make in favor of this, and I just am interested in hearing what you all think. I don't know if anyone actually makes this argument. Does anyone make the argument that that plea bargaining encourages crime because it encourages that people can get let off easy? I'm just wondering. Basically, my question is there a deterrence argument people make? Like that lack of plea bargaining would deter more crimes? So I'm pretty sure that that's not accurate because people don't understand how the legal system works. But I also am wondering if you've all come across it yet.
I mean, like the only article is like, yeah, like the only article is from like 1996, so probably not that recent.
Okay. So probably not. Okay. So, but in any case, the affirmative is still, of course, allowed to make that argument. Anyway. All right. When we get back, we're going to get to our end segment and the only important part of our podcast, the mini debate. Anyway, thank you, Jessica, for coming on our podcast. You were an excellent guest, and we really appreciated you coming on.
Yeah, thanks for having me. I really enjoyed my time. I'm glad that I was on the first decent episode of the Argument Clinic.
Wow, shots fired.
That's my first debate accomplishment.
Oh no! Maybe our best debate accomplishment is having you on our podcast. Certainly, it's the best the best thing of our podcast. You heard it here first. If Jessica's comment angered you, send an angry email to the argumentclinicpodcast@gmail.com,
Or just
chastising her for her
react to
indiscretions.
post on Facebook.
Or that. Okay, so please recommend the podcast to all of your friends. Thank you again to Victory Briefs Institute for supporting our podcast. Now, the only important part of our podcast, the mini debate. I am going to go with best Netflix show.
Oh.
So, I hope you all have seen various Netflix shows, and if you haven't, then it just means that I'm more basic than you, and therefore win. So, I want to take the low hanging fruit, so I can just like think of time for you all to do an answer. But I'm kind of really on a kick for this now, and this will force creativity from all of you. My answer to this question is Stranger Things.
Yeah, I knew it.
Wow, taste it. Now you have to think of one by yourself. Okay. Or Jessica can do one, and then Lawrence, you can just vote. No, sorry. Lawrence, you have to pick a new one, and then argue that it's better, and then Jessica will decide who wins. Or Jessica can offer a third candidate, and then we can choose to abandon ship to hers.
I don't know if mine's appropriate. It's American Vandal.
Oh, I
hmm.
really know what that show is. Can you describe it?
It's like about like youth and crime, right?
Jessica.
Well, I'm trying to make sure that this is the right show. Like, I don't know anything about it.
Just
It is
Jessica,
about youth
could
and
you explain it, please?
This guy, he gets in trouble with his school for spray painting male genitalia cars in the high school's parking lot. And it's basically a documentary investigation of whether he did it or whether he did not spray paint.
Okay, so just like what style of show is it? And kind of like why is it good?
I think it's good because it explores a lot of different potential situations, and there's a lot of very like distinct characters. Think of like a regular public high school, but with all the like characteristics like exaggerated within like each of the students. A very good creation of like each character, and then there's a good analysis of like all the potential like situations and all the potential scenarios that could have happened with a specific answer. But if you watch the entirety of the show, you should know who really like spray painted the cars.
Okay, well, I am going to say that Stranger Things is good because it hits a kind of good nostalgic vibe, so it appeals to a wide range of audiences. It is the pacing is incredibly well done, so if you watch it every time, it's very good at building suspense, taking down suspense when it's needed to, and every scene feels like it really blends very well into the feel of the next scene. It has a large cast of characters, which non-uniques Jessica's argument, because there are a bunch of characters in both directions. It has youthful characters, it has older characters, it has characters that are struggling with like certain disabilities. It has a lot of relatable characters, and it has great supernatural powers, stuff that's involved. It has like good elements of horror, good elements of thriller. It's really just a great all around show. So that is my submission for why Stranger Things is best. Season 2 is incredibly good. And Lawrence, what do you say?
So, are we doing shows that are on Netflix or Netflix shows?
Shows that are on Netflix.
Oh, what? Oh, that changed. Yeah, well, both of you, I think, have picked Netflix originals, right?
Yes.
Well, yeah. So that's what I mean.
Okay. Netflix originals. Okay.
It's the opposite of what I just clarified, but
yeah. Okay. Right.
Netflix original shows. Yeah.
I don't know. I think Master of None might be the best.
Really? That's the Aziz Ansari comedy, right?
Yeah. I don't know. Like, and the weird thing to me is like no single episode to me is super enjoyable. Whereas like I can point to other shows and be like, oh, that's a really, really good episode. It's just the overall, both of the seasons when you just watch them together are just like, I don't know, they're just really good. Like they really they're new perspectives on sort of contemporary human experience, and they had like really good writing, and like the characters were believable enough that you could like relate to them, but just eccentric enough that like you could observe as like an external observer and just be like, oh wow, that's like kind of cool.
Boring.
I don't know. It's just a
Boring.
good show. You don't like Master of
Boring.
None?
I
seen it.
I tried to watch an episode, and as you said, it wasn't very good. so so I stopped.
The first episode I didn't think was very good, but like I think it got a lot better.
You said that you didn't think any of the episodes were particularly good.
Well, none of them are in my mind like super memorable, except for the one that it's about Asian parents, because like my mom thought that one was funny. So
how do you think that you're gonna win this mini debate? Yeah,
Well-
yeah, I'm definitely gonna go for Stranger Things has a lot of memorable episodes. # all of them.
But
And
I
they're
mean,
all
like,
really good.
I mean, if you actually like search up best Netflix shows, I'm pretty sure I feel like Master of None it beats Stranger Things in a
I'm
few
pretty
of
sure
them.
if you introduce the argument that it is on some random list higher, you just automatically lose the debate.
Yeah, that's fair enough.
On moral grounds. I am interested in American Vandal. So, however, I will, Lawrence, you know, given that your Master of None was easily eliminated, I will give you the honor of being the deciding vote between.
It's Stranger Things for me. I mean, it's the only show that I've seen, so
Yeah, got him.
between the two, I mean, there's lots of other shows on Netflix though. It's hard to point to a single best one.
So
It's also cheating because Stranger Things was the one that I was going to pick. So
got him. Jessica, should I watch American Vandal? Like, is it really good?
I think it's really good, but
Is it just so like I do very much like all the quirky high school people, but I mostly just like weirdo high school people for no reason. I find them more relatable.
I think it's funny that at the beginning of the show, before like they really like knew much about like the characters, it's the guy's name who like is the prime suspect is named Dylan, and his mom's maiden name, like the last name is Kavanaugh. So I was like, interesting, you know, like
Dylan Kavanaugh.
that's not his like dad's last name, so that's not Dylan's last name. But I was like, that's pretty cool. I know someone named Dylan Kavanaugh.
That's actually so funny. Dylan Kavanaugh, you should send us an angry email at the Argument Clinic podcast at gmail.com if you feel that Jessica has slandered your good name. Okay, everyone. Thank you so much for coming on. Jessica, we have a tradition where you say where at the end of the episode you say "Stay Frosty," which is our sign off, and you have to say it like really emphasize the A in "stay."
Like the A. So
Yeah.
like the A and stay.
Yeah. So like do it like draw it out, like make it long.
Stay.
And then just
like that.
yeah, like that. Let's go.
Stay frosty.
No, this isn't an argument.
Yes, it is.
No, it isn't. It's just contradiction.
No, it isn't.
Yes, it is.
It is not.